right, well, welcome. It is lovely to see so many of you in person, so many friendly faces. We are delighted to have Zia Nabi, who needs no introduction, I'm sure, and Josh Jackson, who is the newest and illustrious new member of our housing team. Very illustrious, yeah, looking sceptical, but it's definitely true. They will be reviewing recent cases and drawing out some of the key themes from the last year or two of homelessness law. Josh is going to be talking about housing needs assessments and process duties and how they relate to suitability decisions and reviews. And Zia is going to be discussing housing supply, procurement and enforcement. Now, before I hand over to Josh, I want to just make a little bit of an appeal, however. So many of you, perhaps most of you, are members of HILPA, and you might have seen that there was an email earlier on today asking for evidence in relation to a complaint or a super complaint about Lambeth. And I'm sure we have all had terrible experiences with Lambeth in the last year or two. It is diabolical. I'm sure I don't need to tell you. So this is just a bit of a plea, just a completely personal plea to think about your worst cases involving Lambeth, think about what they did wrong and share it so that the complaint can be as well documented and well evidenced as possible. All right, on that cheerful note, I'm going to hand over to Josh.
Hi, everyone. Good to see a few familiar faces. And
sorry.
And it's not going to come as a massive surprise that I'm going to talk about housing needs assessments, although this will also be of some relevance to just suitability procedural duties as well. So I'm going to split this in three parts. I'm first going to give you some background about the duty, and then going to talk about some recent case law, and then, if time permits, have a natter about some implications from those cases and things to watch out for in the future. So starting with the basics, the assessment duty, as many of you know, came into play after the Homelessness Reduction Act with the relief duty. Didn't cause much of a stir at the time, but my reading is that really what the duty is designed to do, it's a reaction to a dynamic of place first, review later. Its purpose is to front load certain of the local authorities' assessments, so their housing officers are in a better position to get their initial placements right in theory. So what can we glean from the duty itself? So subsection 1, we see the duty, but we also see the trigger conditions. So the applicant must be homeless or threatened with homelessness, must be eligible for assistance. And so 2 points there. One is that we're talking about a higher threshold than reason to believe may be homeless and eligible for assistance. So it won't necessarily be engaged at the same time as the 188 duty, but it often is. And the second point is that there's no requirement for priority need. Subsection 2, we see that the duty is prescriptive as to what must be assessed. Circumstances of homelessness, housing needs, what would be suitable, and also support needs. Subsection 3, the assessment must be notified in writing to the applicant. Subsections 4 to 8, we see the PHP duties, often part of the same document, but following the housing needs assessment. Quite closely linked to the relief duty, but steps that an applicant must take and the authority must take so that she can retain suitable accommodation. Although what I would say is that sometimes the PHP duties, while less substantial in some ways than the assessment duty, they can create sort of traps for local authorities. It's quite often, as I see them, for local authorities not, for example, to record an agreement in a PHP or to record the reasons for an absence of agreement, which can be quite an easy way to highlight an error of law. But perhaps more significant are subsections 9 to 11, the review duties. So subsection 9, until such time as the authority consider that they owe the applicant no duty under Part 7, they must keep their assessment under review and the appropriateness of the steps in the PHP duty. So that stays with the applicant to the end of the Part 7 journey. And then 10 and 11, any changes in the assessment must be notified again in writing. You'll get the slides after, but just a couple of relevant paragraphs from the code. The first one, perhaps most relevant, sketching out the sort of things that you can expect in an assessment. So size of accommodation, location, any requirements and needs relating to disability or medical needs. There are 7 cases on the slide, but there have really been 6 cases addressing housing needs assessments. And by happenstance and poor judgment of my solicitors, I've been involved in 3. Quite a slow uptake, as you'll see from the chronology. But now we're really seeing that judgments on housing needs assessments are becoming a feature of the homelessness landscape. And all apart from Mohammed are first instance. In all 3 of my cases, or the cases I was involved in, there weren't any applications for permission to appeal either. I've grouped these in 2 generations. So the first generation involves X, Y, and ZK. And I think in understanding X, Y, and ZK and the limitations, I would say, of those judgments, it's worth remembering that in both cases, the housing needs were actually agreed by the time of the final hearing. And the issue really boiled down to a more limited question of whether the housing needs assessments in both cases actually identified those needs. And that is why we see in bullet point number 1, the first kind of main principle that comes out of those cases is that authorities must identify the nuts and bolts, the key needs of any offer of accommodation. There is a useful distinction drawn in ZK between needs and wishes. Often, at least as I see in practice, you will have an authority recant what an applicant's told them in an interview of what they'd like to happen, but won't actually say one way or another what their assessment of need is, which is really a dereliction of the duty itself. At the final bullet point on this slide, and which I'll come back to at the end if I have time, is perhaps the most slippery. So there's no requirement for one clearly indexed document. And compliance with the assessment duty essentially requires an assessment of the totality of the housing file, as it might be reviewed by a reasonable and sensible housing officer. What on earth does that mean? We'll talk about it later. So second generation, YR and UO number 1. Housing needs in these cases were very much not agreed. And what we see in both judgments is a much fuller exposition of the law. But for present purposes, I would take 5 things, 4 on the slide, from these. And what's useful about UO number 1 and YR is that they really distill the assessment duty down into 4 component parts, breathing life, I would say, into the duty with reference to traditional principles of public law. So component 1 is that the authority must take reasonable steps of inquiry to be able to identify and assess potential housing needs. Those could be with a school, a healthcare provider, could be a face-to-face interview with the applicant, depending on the circumstances. And the idea there is that without those steps of inquiry, an authority won't be in a position to rationally even assess to begin with, or let alone identify what an individual's needs are. Component 2 is analysis and evaluation. It's not enough to identify. There must be more than that. There must be some reasoning. And component 3, identification, coming from XY. And 4 really sits above them all. So the assessment must be sufficiently reasoned to demonstrate consideration of relevant but also mandatory factors, whether they be from the 2012 homelessness order, policies, or Section 11 of the Children Act, also the PSED, I would add, were engaged. And the 5th point, which isn't on the slide, is that the review duty, a point that comes out from both cases, is that whenever there is fresh evidence or information or a material change of circumstances, the local authority must review or must assess afresh an individual's housing needs against the statutory criteria. And what we see in both cases is what I call the house of cards effect. If the local authority, at least in some cases, gets the housing needs assessment wrong, all the suitability decisions that are hitched on that assessment fall like dominoes. Moving to the more recent cases, the first is Ahmed. So for the most part, Ahmed didn't concern the housing needs assessment duty. It has quite an interesting procedural background where basically a judicial review, refusal of permission decision, and a 202 review both ended up going to the Court of Appeal at the same time as the county court essentially relinquished the appeal to the Court of Appeal. But most of the judgment assesses essentially what the reviewing officer was doing and found that to be reasonable. But the points on housing needs assessments, just three short ones, is the first is that there was an interesting undecided point on whether the housing needs assessment could be read in light of a prior vulnerability assessment. So that's really going to the totality of the housing file issue. The second, and here we see some limits to the vitiation or the house of cards effect, is that an omission in the housing needs assessment could have mattered if it had somehow resulted in Mr. Perdios, who some of us may know well, being unaware of something significant. However, there is no reason to suppose that any deficiency in the assessment affected his review decision. In other words, there must be a factual nexus between an inadequacy in the housing needs assessment and the secondary decision that you're then challenging if you want it to be vitiated. And the final bullet point is really Lord Justice Newey putting his shoulder behind the wheel and saying that only in exceptional circumstances should the administrative court intervene when the 202 and the 204 process is available. The next case is SK. So two general points that I've highlighted here from SK. The first, which I cite quite regularly, is Mrs. Justice Lang really underlines the importance of the assessment duty. A highly significant step. It provides the basis on which accommodation will be offered. And if a family's needs are incorrectly assessed, it is unlikely that accommodation offered to the applicant will meet the applicant's needs unless it does so by happy accident. Or as Dexter Dyer's case said in UO number 2, a broken clock still strikes or is still correct twice a day. For reasons in evaluation, we also see Justice Lang reiterating the point that it must be sufficiently reasoned. It's not enough to merely note the factual background. And then on the facts in SK, or in the application, the first point that's relevant to the totality of the housing file question is that it is permissible in principle, in Mrs. Justice Lang's view, for a housing needs assessment to cross-refer back to previous housing needs assessments and personal housing plans. But in this case, there was no indication that the housing officer had taken into account those previous assessments. In other words, there must be some evidence. Maybe it's a cross-reference in the assessment, perhaps some other form of evidence, but really a cross-reference is what was in focus here. And in terms of breach, the first failure really was a failure to assess the circumstances of homelessness. And in this case, why that was significant, and there will be other cases like this, it's because the circumstances of homelessness were quite intimately connected with what the applicant's housing needs were to begin with. So in this case, the applicant became homeless because the accommodation became unreasonable to occupy. And that was to do with her children. Two of her children were profoundly disabled and had degenerative illnesses that were only going to get worse. And that would continue to inform the applicant's needs moving forward. So the failure of assessment of homelessness circumstances kind of infected the rest of the assessment. The second major flaw was a failure to assess the needs of everyone who might reasonably be expected to reside with the applicant. The housing officer in this case hadn't addressed her mind to the question. So what I'm going to spend most time on is UO number 2. So start with a little bit of background. So UO was a single mother of three initially primary school age children in UO number 1. And she'd been made homeless upon being granted refugee status. This is a very common phenomenon. So at the time of UO number 1, the eldest child was in her final primary school year. And she was quite a star, to be honest. She was preparing for her SATs, captain of the school football team, sitting scholarship interviews for independent schools. And really what we saw in UO number 1, quite surprised it actually got to a final hearing, but what we saw was really a series of manifestly inadequate housing needs assessments. And then a series of suitability decisions whereby UO got moved between different hotels every 2 weeks that were between 1 and 3 hours away from her children's school. The only alternative being offers of accommodation in Peterborough. That was quite obviously unlawful. UO number 2 was a slightly different proposition. We had to work a little bit harder for this one. So what happened, the background for UO number 2 was that after UO number 1, the eldest daughter started out in secondary school in Redbridge. UO had gained employment and she'd started she'd continued and then started another adult education course, a real striver. And Redbridge produced a new assessment, which concluded that she was in priority category 2, in its placement policy, which meant highly desirable to be located in the borough, but not essential. And ultimately, we decided to JR that. And that was despite UO being in suitable accommodation at the time. So our reason, and when I say our, I mean Will, he's in the audience, is that while she was in, the risk was that with this housing needs assessment, there was every chance that she could be moved, and Sarah, you're both pointing at each other, that she could be moved to unsuitable accommodation in the near future. So we issued, and then as predicted, 2 months later, 3 months later, UO was moved to the northern edge of Enfield. Now that was only about an hour away from her children's schools individually, but the real kicker about this case is that as a single mother, when you added up the journey that UO would have to take from school number 1 for the youngest kids to school number 2 for the eldest child to her employment, then to her education, you were talking between 2 hours, 3 hours each way per day. And that's what I would take from this, is you have to take applicants as you find them, not as you think they ought to be. So what happened is that we decided we thought alternative remedies were likely not to get permission if we try and challenge suitability with the JR. So we'll leave them separate. We'll pursue the 202. And this was a kind of agreed position between the parties. The 202 decision was then made about 2 or 3 weeks before the substantive hearing, silence. And the day before, we heard that now they wanted to rely on it as reviewing the housing needs assessment. And it would be fair to say that this backfired spectacularly, because we went into our original hearing and Dexter Dias KC thought, well, this is all related, isn't it? So why don't we come back in 2 months and we'll just deal with it all together? And that was actually agreed by the parties at the time, perhaps under a little bit of pressure. And that's how we ended up with UO number 2. So what we see, ground 1, which really does a lot of legwork, addresses the first housing needs assessment. And the first error that jumps off the page was that there was a material error of fact in the housing needs assessment, that there had been no interventions from wellbeing teams in respect of the eldest daughter. And that was contrary to findings in UO number 1 and the evidence. And while that wasn't considered a freestanding basis of illegality, it did feed into the unlawfulness overall, in Dexter Dias KC's view. An interesting quirk of this is that the housing officer sought to explain this by saying, oh, the reference to there being no welfare interventions meant that there's not currently any welfare interventions at the date of the assessment. At the date of the assessment, the children were in suitable accommodation in the borough, so all well and good. This was roundly rejected. And the first reason that it was quite interesting is it relies on the retro reasons cases of Nash and inclusion housing. And Dexter Dias said quite diplomatically that he viewed this explanation with a measure of caution. But in any event, said it couldn't excuse a failure to take into account previous well-being interventions, as they would impact on a predictive assessment of future risk if the applicant was moved outside the borough again. So the second point from this, or the second heading of unlawfulness really, was that the housing officer hadn't adequately considered UO's status as a single mother. And that was an obvious risk that with that status, if she was placed out of the borough, that it would cause an intolerable strain for her and the family. There was also no consideration of adult education, which, you know, while a lot of people may overlook, Article 2 of the 2012 Homelessness Order doesn't specify that it's only child or only or not adult education. And then the final point is that also in terms of Article 2, that disruption to employment, that had to be considered in the context of UO as a single mother. Interestingly, in the policy, there was a presumption that 90 minutes commute to employment would be reasonable for an applicant. And really the takeaway point here is that that may well, as a general presumption, be what people who are applying to Redbridge have to deal with, that isn't a rigid rule to be applied to everyone. Ground 2 concerned the review decision itself, but particularly whether it was a lawful review of the housing needs assessment. And in this, started off that again, Dexter Dias was somewhat skeptical of the review decision and thought it may be confirmatory in nature. And that's because it went on to say, essentially reaffirmed the correctness of the housing needs assessment and used very similar language in different parts. But then also, to the second bullet point, many of the same errors that were shown with the first housing needs assessment really flowed through. The point I find most interesting about ground 2 is the analysis on the team side duty. So our opponent in this case, Andrew Lane, his argument, which I've heard many's a time, is that cramp. If the applicant hasn't basically asked a reviewing officer to make a certain inquiry, then the analysis ends there when it comes to team side. And that was roundly rejected. And I've always thought this, that the team side duty rests squarely on the authority. That an applicant has requested an inquiry or hasn't may be a factor going to the reasonableness of that inquiry or its necessity, but it's not the overall trigger for the team side duty to begin with. And Dexter Dias bolstered that with reference to Section 11 of the Children Act. You know, the Pereira gloss on cramp when it comes to the PSED essentially equally applies for Section 11 of the Children Act. It's not enough just to wait and see what inquiries the applicant asks of you. There was also a misdirection of the policy, which was quite surprising because the exact same misdirection happened in UO number 1 to a large extent. Essentially, if a policy says that, you know, in general, special educational needs, critical schooling age are examples of when someone's in priority 1, they don't necessarily mean that it's only those cases that an applicant is going to end up in that priority category, which is the area that was really running through the assessments in UO number 2. And the final point, which factually is quite interesting, is that the reviewing officer judged his analysis of the reasonableness of travel times on Google Maps. Whereas we had witness statements saying what the lived experience of UO's travel was, that school 1, school 2, employment. And that wasn't enough in Dexter's issue. So the final ground, which Z is going to cover suitability on a fuller basis than me, but essentially is just, in this case, the House of Cards effect applied. The assessment vitiated the suitability decisions. And also there is a breach of Section 208, which was an interesting Tameside point rolled into that, whereas there was a search of 3-bedroom accommodation in or near the borough, but there wasn't 2-bed, which wouldn't have been statutory overcrowding in this case. And given that the primary need for UO was location-based, that ought to have been considered. So what's on the horizon? So the first is the Court of Appeal on the horizon. Because I mean, what we have so far is we have 3 very, very thoroughly reasoned first instance judgments and 3 other, I think, fundamentally consistent judgments with those, but we don't have any appellate authority yet. That'll certainly be a space to watch. The second point is, the second question is, are there limits to vitiation? And I've trailed on this. I've trailed this so far. And ultimately it's a yes. The House of Cards effect has its limits. A suitability assessment must be based on the housing needs assessment for it to be vitiated. There must be what I would call a coincidence in error. You could have a housing needs assessment that really butchers the job on location, but the issue of suitability with one accommodation might be about HMO requirements. There isn't that coincidence of error in those cases. A possible exception to that, but perhaps not, but just a caveat I would add is that there are certain sections in Part 7 that expressly require the local authority to have regard to the assessment. So the relief duty and the prevention, and the intentional homelessness duty are 2 of those. But even then, it would be possible for a local authority to have regard to an inadequate HNA, but not to be infected by its inadequacies, I think. The more difficult question is, what does the housing needs assessment duty mean in the Section 193 context? Most of these cases, or at least YR and the 2 or UO number 1, involved 188. UO2 involved 193 by quite a peculiar background of how it got there. So the issue in 202, which makes it a bit more complicated, is that the review process itself, you will often get a much fuller reasoned review decision that papers over a lot of the errors or failures in reasoning in the housing needs assessment. And if a judge thinks that this has been a genuine reassessment and the same errors in the housing needs assessment don't track through, I don't think there's going to be vitiation. And that's really what Ahmed is authority for, among other things. But not always. I mean, as we see in UO2, number 2, it wasn't vitiation, but the sort of confirmatory nature of it was certainly a factor in our favor. So the third question, how far can the totality of the housing, how big is the totality of the housing file, really? I mean, taken at its face value, the totality of the housing file, I find very hard to reconcile with the requirement that there must be a notification of a written assessment to an applicant. I mean, the notification duty really has 2 purposes as I see it. So the first is to make the housing officer aware of what an applicant's needs are so they can readily understand them when it comes to making offers. And the second is that the applicant can understand how the local authority has assessed their needs and, if necessary, then challenge it. I mean, to me, both purposes are frustrated if a local authority is able to cobble together without no indication, basically anything that could be in the housing file case notes to say, oh no, we actually did consider that. Or actually the housing needs assessment says this about location, but if you go back to page 76 of the housing file, you'll actually see it's this. So there must be limits. And in my view, there are 3, or at least 3. The housing needs assessment, it must identify the needs Otherwise, the applicant won't know. The second limit is that the housing file cannot contradict the housing needs assessment. It may be able to buffer its reasoning or be used as evidence that something was considered at the time, but even that has limits. So limit 3, I would say that it must be clear what parts of the housing file are relied upon in complying with the housing needs assessment. ZK, that wasn't quite the reasoning there, but in SK, I think that shines through, that there must be some indication of what's being relied upon. Otherwise, there's a risk of retrospective reasoning, of people pointing to different parts of the housing file, even though they may not have been the housing officer responsible for it, going, this was considered, this was considered. Question 4, quite a short one, is think of complementary duties. And I tend not to put them as additional grounds, because then what happens is it gets ignored. I tend to weave it in to my understanding of the housing needs assessment duty. So I think there hasn't been a judgment yet in the PSED, but there really isn't a logical distinction between that and how Section 11 of the Children Act has been used in these cases. And the final question is, are the floodgates open when it comes to alternative remedies? And if one looks at the first instance authorities, they might think that the answer to that's yes, but Ahmed is squarely saying the answer is no. When I view them together, I think any clever clogs is going to be able to wrap up a suitability dispute into a housing needs assessment dispute if they try hard enough. There is always going to be, or usually going to be, an overlap between the two, at least when there's a coincidence of error. So the principle I would take is, if you want to unlock the jurisdiction of the administrative court when the 202 and 204 processes are available, there must be something more than an overlap between your housing needs assessment challenge and your suitability challenge. In UO number 1, that something more was that it was the 188 duty to begin with. 193 was accepted about a month into proceedings. And at that point, all the factors of efficient disposal of disputes, delay, that was all pointing towards judicial review. In UO number 2, JR was at the beginning was the only option, because there wasn't unsuitable accommodation and there were distinct issues. And it was really that slightly peculiar circumstance of the local authority trying to rely on it the day before that brought it into play. But another example could be if there's a policy challenge in the offing that might lean towards judicial review. So yeah, that's everything from me. Thanks.
Thank you very much, Josh. I'm going to just hand straight over to Zia, and we'll have some time for questions at the end.
Right. Thank you very much. Okay. I'm going to address 4 specific but overlapping topics. Firstly, interim accommodation. Secondly, suitability. Thirdly, out of borough accommodation. And fourthly, relief. And as I was preparing these slides today, I reflected that actually these are the 4 topics that have engaged me the most in homelessness cases, certainly in the last 12 months. This is what's coming up again and again, sometimes with an overlay of the housing needs assessment, but in terms of hard-edged questions of law, these are the 4 topics that are coming up. Now, I've recently discovered that I'm late to the AI party, but you can ask them to prepare you a picture of interim accommodation in disrepair. So I did that this morning. I said, please, can you make me a picture of interim accommodation in a hospital in disrepair? Now, you're going to be interested to see what it came up with. That's what I got. Not my own work. I mean, I'm not sure whose work it is. But yes, I don't think things have got quite that bad yet, although there have been cases where I've come close. The first case I want to talk about is the case of Yabari and Westminster City Council. Now, This I find factually a very odd case, and I find it quite odd that it got to a final hearing. So in this case, the claimant said that he was homeless at home. He lived in a flat, and he approached the local authority, who asked him to complete some forms. And there was a bit of toing and froing as to whether those forms needed to be completed or not. And he issued proceedings saying that Westminster had refused to accept the homelessness application from him. Soon after he had issued proceedings, the council offered to move Mr. Yabari to other accommodation, and Mr. Yabari refused, saying that he'd been where he had been for about 4 years and he was quite happy to carry on living there whilst the judicial review was completed. So I find that factually quite a difficult matrix to comprehend as to how then that gets to a final hearing. But I think that factual background, because judges keep telling us context is everything, I think explains what the court decided in this case. So the court accepted that the interim accommodation duty is immediate and non-deferrable, and that the threshold is low, and that it can only be discharged by suitable accommodation. Importantly, it said that the interim accommodation duty is over and above the homelessness relief duty. So a local authority can't say we're performing the homelessness relief duty and therefore we don't need to look at section 188. But, and again, this is not new law, a local authority can say that we accept that the interim accommodation duty under 1881 is owed, but we can perform it by leaving you where you are, because the reasonable to continue to occupy test under 175 subsection 3 is more readily met than the unsuitability test under section 206. Now, in this case, Mr. Yabari was on the 4th floor. He had mobility issues, and the court said that he couldn't be determined as safe in his flat because of the fire safety risk, and that the council's decision that the accommodation was suitable for section 188 was irrational because it didn't take fire safety into account. So this case is a useful example of 188 accommodation being deemed to be unsuitable by and it being an irrational decision when fire safety is taken into account. But the judge said it doesn't really matter because it actually had no consequence, because Mr. Yabari had said he didn't want to move, he wanted to stay put. The court did point out that he could have changed his mind, and if he had changed his mind, then at that stage Westminster would have been under a duty to move him. So why have I put this case in? I think for 2 reasons. Firstly, that it sets out clearly that the homelessness relief duty and the 1881 duty are 2 separate duties, and the 1881 duties are over and above. And secondly, that this is an example of irrationality in 1881. Apologies. Bed and breakfast accommodation. Surprisingly, this order was, as you will see, was brought in 2003. It limited the use of, actually, I shouldn't say bed and breakfast accommodation, that's an error. B&B accommodation. And the reason I make that not pedantic distinction is that you can have B&B accommodation where no breakfast is provided. So everyone says bed and breakfast, but actually, and as in the case of Pickford we're going to have a look at, the judge noted that technically B&B accommodation shouldn't be called bed and breakfast accommodation. So we had this 2003 order which said that B&B accommodation is not to be regarded as suitable for an applicant with family commitments either under 1881, 1902 or 201 Housing Act 1996. And then an exception was made that you could use this accommodation for no longer than 6 weeks when no other accommodation was available. Family commitments are defined as where a person is pregnant or has dependent children, or is someone, or the applicant is residing with someone who's pregnant or has dependent children. And then B&B accommodation, I'm doing it myself, B&B accommodation is defined as accommodation whether or not breakfast is included, which is not separate and self-contained premises, which cooking facilities are not provided, and amenities are shared, and the accommodation itself is not being provided by a local housing authority or a non-profit registered provider of social housing, or a voluntary organisation, or accommodation that's in a private dwelling. So if someone is letting someone stay in their house, that won't count as B&B accommodation. In recent years, I've noticed that there's a certain resignedness to the fact that homeless applicants are being put in B&B accommodation and left there for longer than 6 weeks. And it just started, in my experience, just to become something that crept in through the back door, and people would be in B&B accommodation for months and months and months. And there was no real authority on this. So in 21 years, there'd never been a judicial review case, dealing with the 2003 statutory instrument. And that changed with the case of Pickford and Sandwell Metropolitan Borough Council, where Mrs. Pickford was in a hotel which was accepted to be B&B accommodation. One of the issues in this case was that Mrs. Pickford was separated from the father of her child. And the usual contact arrangements were that the child would go and stay with father for 2 days a week, and then would spend 5 days a week with mum. And the local authority said, well, now that you are homeless, she'd been unlawfully evicted. Now that you are homeless and father's willing to have the son for all week, you are not an applicant with family commitments. And that got short shrift from the court. An applicant with family commitments covers an applicant with whom dependent children reside or might reasonably be expected to reside. So those are alternatives. So if a dependent child is actually residing with an applicant, then that applicant has family commitments. And the court said that you are not allowed to use B&B accommodation for more than 6 weeks. And once the 6 weeks period has expired, then there's a hard-edged rule that the hotel is unsuitable. And although the judge said, had Article 3 not been there, he wouldn't have found that it was irrational to use this B&B accommodation. He said because Article 3 was there, it would have been irrational for the council not to have moved Mrs. Pickford. He didn't have to make an order in the event because the council, seeing which way perhaps the wind was blowing, agreed to move Mrs. Pickford to non-B&B accommodation. But he said he would have made a mandatory order if necessary. So this is important, that if there are homeless applicants who've been B&B accommodation for more than 6 weeks, they shouldn't be there 1 day longer, and a mandatory order should be sought urgently, asking that they be moved. Pickford is one of those cases where the pleadings on both sides were relatively short, and the judgment is incredibly long because the judge got very interested in this order. And after the hearing had been completed, I think I've never had as many emails from a judge after a hearing had finished, asking for comments on various points that that had occurred to him post-hearing. So, what occurred to him post-hearing? The judge accepted that accommodation that's provided under Section 1881 can switch to being Section 193 accommodation once the main housing duty is accepted, and we all know that that is right. But he said that accommodation can't switch to becoming accommodation that's being used to perform the homelessness relief duty. He said that's because that is not one of the ways in which Section 1881 comes to an end. So as you know, Section 1881 has been amended to explain in quite prescriptive terms how the 1881 duty comes to an end. And those are the sections 1ZA, 1ZB, or 1A. And he said that discharging the homelessness or performing the homelessness relief duty is not one of the ways in which the 1881 duty comes to an end. So that meant, he said, that 1881 accommodation cannot be used, it cannot switch to becoming homelessness relief accommodation. He also pointed out that the relief duty was not a duty to secure accommodation. And if the authority was already securing accommodation, then by continuing to provide that accommodation, it couldn't then say, well, we're now taking reasonable steps to help the applicant secure accommodation. He said that sort of switch is an unlawful sidestepping of the duty under Section 188. So do not let the relief duty obscure the fact that the 1881 duty persists and is over and above and distinct from the homelessness relief duty. ZRR and Bexley. So this again was B&B accommodation. I've made the error myself there. B&B accommodation, it was provided in performance of the Section 1902 duty, which, as you are aware, is the limited duty, accommodation duty to the intentionally homeless. And there was a challenge brought on the basis that this accommodation was not suitable. And in this case, the court said, well, after you can use B&B accommodation for up to 6 weeks, but only when no other accommodation was available. Now, I think in this case, the applicant had been in B&B accommodation for 2 weeks. And the court said that the council had failed to provide evidence that no other accommodation was available other than B&B accommodation to perform the 1902 duty. And the judge went on to say that no reasonable local housing authority could be found that the B&B accommodation was suitable even for 14 nights. So if there's one point, perhaps rather oversimplistic point I'd like to make, it is that one should not be resigned to accepting B&B accommodation for applicants with family associations, because we all know, well, perhaps that's putting it too highly. It is certainly in many cases the fact that children are very adversely affected by being in B&B accommodation for a significant period of time. And so a local authority that is adopting a policy effectively of automatically putting people in B&B accommodation when applicants apply as homeless is arguably not thinking things through properly and is following an unlawful procurement process. And its homelessness strategy needs to be looked at. The B&B should not be the first port of call. It should be the last port of call. But too many authorities have, that seems to have gone for too many authorities. Now, Bexley in this case had tried to say, well, we've got B&B, or we can move the applicant to Manchester. And and that won't be in B&B accommodation. And the court said, well, that was flawed because it failed to take a lawful account of the younger child's education needs. Now, again, if I can make another general observation, it seems to me in the last 12 months, there have been a number of cases which, when dealing with out-of-borough accommodation, have looked at the impact on children's education. And judges have used Section 11 of the Children Act 2004, as well as the provisions for education, to say, well, unless you're satisfied that the education needs of the children will be adequately met, you can't simply move people out of the borough. And that worked in ZRR, in for 1881 accommodation. So when I started preparing these notes, I was quite surprised to see that there were 2 cases where the rationality of 1888 accommodation had been challenged and had succeeded. But one always assumes, because 1881 accommodation is so short term, it must be very difficult to establish that it's irrational to offer a particular unit of accommodation. And that's true, but these cases show us that it's not impossible. Kyle and Coventry City Council was a second appeal before the Court of Appeal, and effectively dealing with whether a halfway house type accommodation given to people who had mental health and drugs issues. So it's meant to be very short term. They were provided with support, and it was just move on accommodation until some other offer of accommodation was made. Whether that accommodation was similar to refuge accommodation in the case of Arways and Birmingham City Council, Moran and Manchester City Council. As you will recall, in Moran and Manchester City Council, which was 2009, Mrs. Moran was accommodated in a domestic abuse refuge, and she was evicted from that because it was alleged that she had committed acts of antisocial behaviour, and she was subsequently found to be intentionally homeless. And the House of Lords held that she couldn't be intentionally homeless because a refuge was never accommodation that was reasonable to continue to occupy for the purposes of Section 191, and therefore you couldn't be intentionally homeless if you were asked to leave. Now, in this case, Mr. Kyle had been accused of antisocial behaviour. He'd been accused of breaking into other rooms and trying to steal possessions of other occupants. And it was found that he was intentionally homeless. And the argument was, well, there was no difference really between a domestic abuse refuge and this type of halfway accommodation. They're doing the same thing. And the first instance judge and the Court of Appeal disagreed. They said that the halfway house intended to provide support for recovering drug addicts was distinguishable from the refuge occupied by Miss Moran. Why? So because a refuge was a temporary safe haven, there were not places to live. Miss Moran had no right to any specific room, was forbidden visitors from bringing men into the surrounding area, from giving her address to anyone, from having contact with neighbours, and from disclosing the nature of the building. And all those things taken together meant that the quality of the refuge, the characteristics of refuge was different from this halfway house accommodation. Now that does seem pretty emphatic, but I'd just like to make a couple of points about that. Firstly, at the review stage, this point was not taken. So it wasn't argued at the review stage the halfway house was not reasonable to continue to occupy, because actually Mr. Kyle couldn't have visitors where he was staying. There was a curfew where he was staying, so he had to be in at 8 o'clock. He wasn't allowed to smoke in his own room. So there were a number of quite strict restrictions on how he could live in that property. But it was never raised on review. It was something that was argued on appeal, and the court did note that effectively this is now coming in right at the last minute. The Supreme Court refused permission to appeal on this case. But in my opinion, the point is still arguable in the correct case, where there is someone in some sort of halfway house recovery type accommodation for a very short period of time. It could be arguable that that is similar to Moran type accommodation. As you will recall, in Arways, Baroness Hale, when she was defining what it meant to be, what was the characteristic of accommodation that was reasonable to continue to occupy, used the word indefinitely. So if you can't live somewhere indefinitely, then it's not reasonable to continue to occupy. And that has caused the Court of Appeal in several cases post-Arways, I wouldn't say pause for thought, but it's something they've had to analyse. What did Baroness Hale mean by the word indefinitely in Arways? And what the Court of Appeal said in Kyle was that you don't have to be entitled to remain in accommodation indefinitely or for any particular period of time for it to be reasonable to continue to occupy. So effectively they said, if you're somewhere which is very nice, I think they use the example of a flat near Hyde Park, and you only had 3 months left on the tenancy agreement. They said, well, that you wouldn't be homeless there. That would be reasonable to continue to occupy. And in my view, I think that must be right. I think the arguments that you have to be able to live somewhere indefinitely for it to be reasonable to continue to occupy is not going to find much favour with the courts, and Kyle has sort of put the stamp on that. I'm going to move on now to suitability and out-of-borough accommodation, which I'm going to look at together. This was what, when I asked for do me a map of out-of-borough accommodation, this is what I got. So firstly, the case of Gowie and Waltham Forest, LBC. This is an interesting challenge. Second appeal, Mr. Gowie was a homeless applicant who wanted his child to attend an Islamic school. And he argued that the suitability decision was unlawful because it didn't recognise that his preference for single faith education was protected by Article 9 of the Convention, freedom of thought, conscience, and religion. And the Court of Appeal, first instance, the appeal was unsuccessful, and the Court of Appeal dismissed the second appeal. It held that homeless decisions can engage convention rights, which must be right, obviously, but that instances of violation would be very rare. And importantly, they said, decision makers don't have to identify the rights and then potential violations. What they do is a decision maker conducts the review or the initial decision making, and then comes to an outcome. And it's the outcome that deals with any rights. There's no need to follow any particular process to ensure that those rights are properly highlighted and dealt with. And the court said the court had been entitled to conclude no interference with Article 9 of the facts of the case. And even if Article 9 had been interfered with, the applicant would likely to face an insuperable task in arguing that his faith-based preference should give him priority over other homeless persons. So not much joy for Mr. Gowie. The case of Zaman and Waltham Forest, London Borough Council. I'm going to talk about two cases, but out-of-borough accommodation with different results, both in the Court of Appeal. And we can think about why different decisions in these two cases. So it's right that local authorities should accommodate within their own district unless not reasonably practicable to do so. If it's not reasonably practical to do so, then they've got to provide accommodation as near as possible to their own districts. Now, Waltham Forest have an acquisitions policy which showed the how it obtained accommodation to satisfy its duties to the homeless who were owed the main housing duty. But the court said that although the policy itself was fine, there was no evidence to show that it had been followed in that particular case. So, I mean, perhaps this is too cynical and a conclusion to draw, but it might be said that a local authority has an acquisitions policy, a procurement policy, and explains how it will accommodate applicants out of borough. But when it actually comes to the meat of a particular case, what it's actually doing is seeing what's available on that day and just taking the first taxi off the cab rank without seeing whether there are any other taxis available or which might be coming along in a short period of time. And the court said in this particular case, there was a dearth of evidence to show that they actually had followed their policy about how to both obtain and then provide accommodation. And that the evidence that they'd provided hadn't shown that because what Waltham Forest do, as you know, they have zones A, B, and C. And then depending on what your applicant's needs are, then leads to whether an applicant will be accommodated in zone A, B, and C. And then they said, as far as zone C properties, they couldn't understand that how the council had been trying to ensure that those zone C properties were as close to the Waltham Forest as possible. And they hadn't explained why so many properties were in Stoke-on-Trent, when common sense indicated it would normally have been possible to obtain accommodation closer to the borough. Now, my suspicion is that the court was sympathetic to the facts of Mr. Zaman. But this is good Court of Appeal authority, and the court there refers to common sense in favour of the applicant as opposed to in favour of the local authority, which has not always been my personal experience. So it is a good case, and so out of borough, if someone is being accommodated miles and miles away, Zaman is a useful authority to try and understand how that decision might be challenged. Now, the next case, which failed, and see if you can spot the differences. This case concerned the homelessness relief duty, so not the main housing duty, but that doesn't matter for our purposes, and out of borough accommodation. Now, Miss Moj, she refused accommodation of a 24-month AST in the neighbouring London Borough of Hounslow. So it's not Stoke, it's Hounslow. And there was nothing in the decision letter or the review decision to indicate what inquiries the council had actually made to locate properties for her other than the flat they offered her in Hounslow. Now, the difficulty was Miss Moj hadn't raised this at the review stage or at the first appeal stage. So there was nothing in the review decision or the -2 letter explaining what inquiries the council had carried out to find suitable properties for Miss Moj. And the court said, well, that's completely understandable because it is not a point that had been raised. So interesting, perhaps, aspect of the Tameside duty that Josh was talking about. In this case, the court has said, well, if you're going to argue that you haven't made enough inquiries to be satisfied there's nothing available in Ealing, that's something that you should have raised. And the way that the Ealing dealt with it was they then provided evidence in the Court of Appeal, where the point had been raised for the first time, explaining what exactly they had done to provide accommodation in Hounslow and why there'd been nothing in Ealing. Now, acknowledging the dangers of post-decision justification, the court nevertheless let this evidence in, although it said it was only just going to let it in. And then they found that Ealing had not acted unlawfully. And paragraph 122, they said it's not the law that a local authority has to give chapter and verse on each and every internet search and property search that it makes, intolerable burden. But the question of how detailed and specific the information provided will depend upon the facts of the particular case. So Ealing Hounslow, perhaps the court is not that concerned as it would be if it were Ealing Stoke, and there were children, and there were other issues. So this question about accommodating applicants out of borough is always going to be fact-specific and context-specific to make sure that those points are raised at the review stage. Otherwise, you may be prevented from raising them at a later stage. And the court said there may be a case of more detail was required, and it pointed to Zaman as being one of those cases. So my view is, if you want to challenge out of borough offers, Zaman is a good case to go to because Moj approves it. It doesn't say that it's needs. And then, got another point. Yeah. And then went on to say that there's got to be flexibility in applying the principle. But, and this is 4 lines down in that quote, once it is shown that nothing is available in Greater London, suitable and affordable accommodation is likely to be available only in metropolitan areas, such as the West Midlands. The local authority is not required to scour every estate agent's window between Brent and Birmingham. So, fact dependent. How sympathetic will the court be to the facts of your particular case? That will, in my view, have an impact on what it required the local authority to have been done to have done. I think I'm quickly coming to an end. So I'm going to Wire and Lambeth. I'm going to look at very quickly, just to make this point. that Section 11 of the Children Act is important when you're looking at moving people, families out of borough. And the important point in YR is the 5 of the 6 school-age children only been attending school for a term and a half. Local authority said, well, they've not been at school that long. They can go to a different school. And the court said that didn't alter the defendant having to assess their welfare and how a move to another school would affect them. And other point is the duty is not only to safeguard, but it's to actively promote children's welfare under Section 11. And the court made that distinction. And, this is another case. So the court said, in the absence of a lawful assessment, it wasn't open for the defendant to conclude that the claimant only had a wish and not a need to be located in Lambeth. And that the defendant had acted irrationally in concluding that the property was suitable accommodation for the purpose of Section 108(1). And we'll very quickly now move to relief. So the leading case on relief is Sarah's case of Imam and Croydon. And these are points that you will all know now. You will get these slides after the conference if you haven't had them already. But the headline point is this, that where Parliament imposes a statutory duty, it assumes that the authority has resources available to comply with the duty. And it's not for the court to weaken that duty by routinely declining to grant relief. However, the court shouldn't make a mandatory order where it's impossible for the authority to comply, but the onus is on the authority to explain why a mandatory order should not be made. And that's an objective question for the court. And the longer an authority with notice of problem sits on its hands, the more important it may be for the court to enforce the law by making a mandatory order. And that's why when you're dealing with your clients, if there's one authority where the same issue is occurring again and again and again, that is something that you can refer to, that can be referred to when the question of relief is being considered. And in terms of, the court made 5 comments about what to look at about whether one should be granting relief or not. Firstly, it said ask if a local authority's got a contingency fund. Because if when they've set their budget, they've got a contingency fund, could the applicant be provided with accommodation via that fund? Had the authority been on notice in the past of a problem in relation to non-performance of a duty, but failed to take the opportunity to react to that in good time? If a local authority knows in 2023 it hasn't got enough accommodation to deal with homeless people, then it hasn't done anything to address that at all, then that is a reason for the granting of mandatory relief. The extent of the impact on the individual on whom the duty is owed, really important if you're seeking relief, to put in a detailed witness statement from the claimant explaining what the impact of the unsuitable accommodation is on them. If there's no sign of things improving by the time the court hears the case, that's a factor pointing in favour of the mandatory order being made. But the court said also you can't create a situation which is unfair to others by giving a claimant undue priority over others. I mean, Sarah maybe will be able to explain this. I don't really understand that. You go to court to act for your client who is owed a mandatory duty and you're seeking relief for them. It would be open for other people to do the same. I can't see how seeking vindication of your mandatory right is somehow unfair to other people who are similarly owed.
That is what we kept saying to them.
You kept saying that. I'm sure you did. This is why I'm not in the Supreme Court. And one of many reasons. And then we have Pickford and Sandwell. So we've already referred to Pickford and Sandwell under the B&B accommodation. But it's also, as I said, because the judge engaged with this case so enthusiastically, he also had quite a long passage about relief, which can be used generally in relief cases. And under 188, he noted that duty is also not qualified by reference to resources. But in terms of how he said what you should provide to the court, he said that there should ideally be evidence from the claimant themselves, which explains what's happening and detailing the impact of the accommodation on them and their family. And such evidence is more likely to have weight if it calmly details the impact on the applicant and explains why a mandatory order is justified, notwithstanding undoubted pressures on authorities, rather than just making series of bold assertions and shrill complaints. So my takeaway from that is, please do not make bold assertions and shrill complaints in your statements, but make calm and calmly detail the impact on your applicant. That will be more likely to find favour with the court. And then what does the authority have to do? So this is interesting. The authority should, he said, it may be helpful for the authority to detail its budgetary position and relevant aspects of its current budget, to detail the availability of its own and other local housing resources, explain any relevant policies it's adopted, helpful to provide the current homelessness statistics tailored to the case, address in evidence what they say about the impact of breach on the individual, and then to present the court with different realistic options and evidences of their. So that I think this is helpful for authorities because it gives them a template about what they need to show to the court to demonstrate that they have taken all reasonable steps to provide accommodation. And then very finally, this is a case which I haven't been able to find a judgment. It's on the Nearly Legal website. What I find interesting about this case is that the authority said we haven't got anywhere. And the claimant filed reply evidence, which identified several units of self-contained accommodation in a suitable area, which were available on a nightly or short-let basis. And the local authority said, oh, no, well, we can't use those because we've got this very complicated system of procurement, and we've got to do all sorts of checks and tests to make sure that accommodation is appropriate. And the court wasn't having it, and the court made an order for mandatory relief. One final thing I just always occurs to me with accommodation and out-of-borough accommodation is that a number of local authorities in London are part of a system where they all subscribe to the same scheme where accommodation becomes available. And there doesn't seem to be any distinction in that scheme about people, for example, in Ealing, getting priority for any accommodation on that system, which is in Ealing. And they seem to pool their resources to try and find accommodation on a first-come, first-served basis. And that's been going on for quite a long time. I think called the Adam system. Certain, I don't know if people have come across that. And I've always thought to myself, that can't be lawful, where the system itself doesn't give priority to applicants within districts rather than being cross-district. Anyway, I'm so sorry for having terribly over.
No, that's absolutely fantastic. I believe that this seminar was billed as being an hour long. I will confess that I secretly knew that it was going to be an hour and a half. So sorry for not sharing my secret view, but I think that means we've got 10 minutes for questions. If you're all happy with that, if you can give me a sort of vague, okay, well, all right, well, we'll try and keep it brief, but do we have any questions for Josh or Zia? Yes.
Do you think it's possible for the authority to bring the relief duty to an end by say they offer private rented accommodation, it was actually suitable for the person and they turn it down. So let's say substantively on the merits, it was actually suitable, but they've never notified the person of the assessment. Because if you just read section 189B, subsection 7, in the list of reasons, it doesn't necessarily make it contingent on having notified of the assessment, although they have to have regard to the assessment. It's like, can you basically get them out of having turned down suitable accommodation on a procedural defect in that way.
Should we put that one for Zia?
Sure. Well,
Yeah.
the relief duty is not a duty to provide accommodation. The relief duty is a duty to take reasonable steps to assist someone to find accommodation. If the authority says this is accommodation, it's available to you, we've helped you find it, it's suitable, then you can challenge, and you say it's unsuitable, then you can challenge the suitability of that accommodation. If you say it's suitable, then you will have entered into a tenancy agreement and you will no longer be homeless.
What we're seeing is people come to us after they've already refused it. They didn't want it for some reason. For example, often they just didn't want private accommodation. But substantively, when we're going through it with the client, it wasn't actually unsuitable for them. We don't think there's any merits to that challenge, but the authority never gave them anything in writing ever, no copy of the assessment. Obviously, if they'd come to us first, we'd have told them to accept it.
Do you want to say something about that? That's your
I
house
mean-
and cards theory, isn't it? Not theory, but
I mean, it's the question really not about the circumstances that can terminate the relief duty. So that just requires looking at the provision itself, and it will enumerate probably exhaustive circumstances in which it comes to an end. And I don't think that's one of them.
Suitable offer that if it would have been available for at least 6 months, and it was, that's one of the subsection 7 reasons they can end the relief duty. So it seems to me that subsection C, they've refused a suitable offer of accommodation and it would have been available at least 6 months. Well, that just applies. But can we get them out of this because they were never notified of the assessment?
Sorry. I mean, it seems to me like you have a material, like whether it's a material error kind of issue. And so if they're being notified of the assessment might have influenced their decision making, then maybe you could say something about the fact that they've missed out. This is absolutely off the cuff, by the way. I have no idea if this works, on some kind of opportunity to make an informed decision. But if they were told all the ordinary health warnings and so on, you know, I think would it have made any difference? I think the court would want to know.
I'd agree with, sorry.
you know what Giles would say to this? He would say, this is why you should always have a housing lawyer with you. Because really the answer is that clients need to come to us sooner. And it is really unfortunate and often.
Could I just add my 2 cents? Surely under 189 B9, they have a duty to keep the PHP updated. So that's relevant. And if they haven't done that before ending the duty, in respect, could that help?
So I think the answer to this is it's going to be fact dependent in terms of bringing the relief duty to an end. If they can lawfully be satisfied that the applicant has suitable accommodation available and a reasonable prospect of having suitable accommodation available for at least 6 months or a longer period, not including 12 months, that's the relief duty ended. Now, if you want to say they can't be satisfied because either they haven't carried out adequate inquiry, because they haven't reviewed the PHP, or that the accommodation itself can't be deemed to be suitable, or there's some other legal error in their decision that the accommodation is suitable, then you can challenge the decision that the relief duty has come to an end.
Yeah, and just to pick up on Alice's point, again, there has to be a coincidence of error between the housing needs assessment and ultimately the decision made under the relief duty. If it's suitable, even if you have a horrible HNA, there isn't any sort of fact nexus between the two to deficiate the suitability decision. And if the authority hasn't had regard to its assessment, that would technically be a breach of 189B3, but it wouldn't be a material error. So, you know, section 31 of the Senior Courts Act would be coming to bite pretty quickly if it was a JR.
Any other questions? Will?
First one that's completely unrelated to anything you've talked about, but it's
If it's completely unrelated, do you want to talk about it afterwards?
Yeah, okay. Yes, it was about 204A appeals, just whether,
All right, let's
That-
save that one. Let's save that one for
Okay.
afterwards. Sorry, I feel like I've shut you down now. I feel really bad. All right, let's go and have a drink. Let's have some food. If you think about questions afterwards, I'm sure that Josh and Zia will be very happy to discuss them. All right, thank you very much. Well done.